The HOA president called me a squatter at a meeting with 40 people watching. She said, and I quote, "You don't belong here. You don't understand how things work here. And frankly, you never will." She was smiling when she said it, that practiced, tight little smile that people wear when they think they've already won. What she didn't know, what none of them knew, was that I was sitting on a document that made every single one of their homes legally mine. Every acre, every inch, and I hadn't said a word yet. His name was Gerald Maddox. He was a civil engineer from rural Tennessee who moved to North Carolina in 1971. By the time he retired in 2004, he owned just over 1,300 acres in a part of the state that was starting to get attention from people with money. They came in, built a gated community called Sycamore Preserve, 214 homes, a clubhouse, two retention ponds they called amenity lakes, a pool. The ground rent, what homeowners paid as part of their HOA dues, had been set at a flat rate in 1999 and never adjusted for inflation. I'm his granddaughter. I'm 34 years old. I have a background in real estate law, and I am the sole heir to 1,300 acres. Diane spent 2 months going through my grandfather's original ground lease, all amendments, all correspondence, and the current HOA's governing documents. The board president was a woman named Claudette. She ran the meeting with a kind of theatrical authority, cutting people off mid-sentence. One elderly man nearly in tears over a fine he'd received for having a garbage can visible from the street for 40 minutes on a non-collection day. The certified letters arrived on a Tuesday. By Thursday, Claudette had called an emergency board meeting. It argued, and this is my personal favorite, that my grandfather had made an informal verbal commitment to never raise the ground rent. She organized a town hall and told 200 people that I was a predatory outsider trying to destroy their community. I was in the room, in the back, again. I read aloud the provision in the ground lease that explicitly granted the landowner, me, the right to attend any community meeting held on leased property. 3 homeowners approached me afterward. One of them was the elderly man with the garbage can fine. What I actually wanted was a renegotiated agreement, a fair one, a homeowner appeal process with teeth, and Claudette's resignation from the board. Within 72 hours, the HOA's own homeowners had organized a petition, not against me, against the board. Claudette called me personally, first time she'd ever dialed my number directly. Her voice had changed. An independent financial review found $34,000 in administrative expenses that could not be adequately accounted for. That matter was referred to the county. The elderly man with the garbage can fine got his $150 back. The board voted to issue it as a credit on his account. Justice doesn't always yell. Sometimes it just shows up with the right document at the right time.